Divorce Laws in Florida, a comprehensive guide. Divorce can be a challenging and emotionally draining experience, and navigating the legal process can be complex. If you're considering a divorce in Florida, it's crucial to understand the state's laws and procedures. 1. Grounds for divorce in Florida. In Florida, there are two primary grounds for divorce. Irretrievable breakdown of the marriage. This is the most common ground for divorce and does not require proof of fault by either party. Mental incapacity. This ground requires proof that one spouse has been adjudicated mentally incapacitated by a court and is unable to maintain a meaningful marital relationship. 2. Residency requirements. To file for divorce in Florida, you must meet certain residency requirements. One of the spouses must have been a resident of Florida for at least 6 months before filing for divorce. 3. Filing for divorce. The divorce process begins by filing a petition for dissolution of marriage with the clerk of the circuit court in the county where you reside. The petition must include specific information, such as the date and place of marriage, the names of the spouses, and the grounds for divorce. 4. Service of process. Once the petition is filed, the other spouse must be served with a copy of the petition and a summons. Service of process can be done personally or by publication. 5. Temporary orders. During the divorce proceedings, the court may issue temporary orders regarding child custody, visitation, spousal support, and property division. These orders are intended to maintain the status quo and protect the interests of both spouses and any children involved. 6. Property division. Florida follows the principle of equitable distribution when dividing marital property. This means that the court will divide the marital assets and debts fairly, considering factors such as each spouse's contribution to the marriage, earning capacity, and non-marital assets. 7. Child custody and support. The court's primary consideration in child custody matters is the best interests of the child. The court will assess various factors, including the parent's parenting abilities, the child's relationship with each parent, and the child's educational and emotional needs. Child support is also determined based on the parent's income, the child's needs, and the parenting plan. 8. Spousal support. Spousal support, also known as alimony, may be awarded to one spouse to provide financial support during the transition period following the divorce. The court will consider factors such as the spouse's income, earning capacity, and the length of the marriage when determining whether to award spousal support and the amount. 9. Mediation. Florida courts encourage couples to consider mediation as a means of resolving divorce-related issues. Mediation is a process in which a neutral third party helps the spouses reach agreements on matters such as child custody, visitation, property division, and spousal support. 10. Final judgment of dissolution of marriage. The divorce process concludes with the entry of a final judgment of dissolution of marriage. This judgment legally dissolves the marriage and incorporates the terms of the settlement agreement or the court's decisions on child custody, property division, and spousal support. Navigating divorce in Florida can be complex, but understanding the legal framework and seeking guidance from an experienced family law attorney can help you protect your rights and interests. To learn more about divorce laws in Florida and get practical tips on managing this challenging time, subscribe to our channel.